various aspects in terms of reopening procedures and policies and employment law. So I know we talked about Anne, but in the description when you registered, but bonus, you get an extra speaker. So extra, two heads are better than one, and I'm excited to get this conversation going. So before we get started, I just want to remind everyone that if you're not speaking, please keep yourself muted. Just out of respect for those that are speaking. If you have any questions at all, please feel free to type questions in the chat box, or you may unmute yourself and ask those questions out loud if you would prefer to do that. Either way will work. And let's get started today. So Anne and Mike, welcome. I don't know if you want to tell everyone a little bit about yourself. I think most people are pretty familiar with you too at this point, but share a little bit about yourselves and then kind of tell us what's happening.
Well, I'll start and then I'll turn it over to Mike to introduce himself. I'm Ann Searink. I work for Foster Swift, and I practice mainly in the area of library law. So I have been spending, I think, the last 3 months trying to work with many of you, trying to manage all these new and different times and all these new and different issues. And I think because we still keep needing these types of conversations, it's clear that, you know, there's still some confusion out there. And so we're going to try to address some of those issues today. I'll turn it over to, the reason I have Mike here is that, you know, when we discussed the topic of this, we were really talking about reopening and patron issues, but the questions that started coming back had to do with employment issues. And anyone who knows me knows I am not an employment lawyer. I don't dabble in employment law. That's why Mike is here, because this is Mike's area of expertise. So I thought between the two of us, hopefully we can answer many of your questions. Mike, you want to give a little detail about yourself?
Sure. I think Ann just said most of what I was going to say, but yeah, I'm partners with Ann at Foster Swift. I do specialize in labor and employment, both on the private and public side. On the public side, I represent a lot of municipalities and work with a lot of libraries for labor and employment issues. So I have kept an eye closely on COVID-19 issues and the executive orders and CDC and OSHA that we're going to talk about today. And so I'm here to answer any questions you may have from the employment perspective.
Well, again, thank you so much for joining us, and great introductions. Oh, it looks like we already had one question come in, but why don't you, and I know you said you wanted to share a little bit about some of the mask policies and things like that we've been getting a lot of questions about. So why don't you talk a little bit about that, and then we'll get into some of those questions that are coming through.
Thanks. I know that a lot of from my clients and a lot of the questions that came through, I think, when people registered for this session, has to do with masks. I know Claire's here somewhere too. So Claire, if you disagree or if there's something else you can add, please feel free to join in. Claire and I have been kind of working on these issues over the past couple months. What the issue that we come up with is masks. And I know there's a lot of confusion. And here I'm going to give you my caveat disclaimer. I'm going to give you my opinion of what I think the executive orders say. The executive orders are mushy, I guess, so they're unclear at times. There's different interpretations. So I will tell you what I think, but I really request that you go back to your own personal attorney before you implement a mask policy and discuss it, because there's some of the things we can't really get into the fine details in the case-by-case basis that your library may be facing versus other libraries in general. So I'm kind of giving you the general overview of where I think the mask issue is. And the question I get most is, well, aren't masks required? And if so, why are libraries deciding whether or not to enforce the mask requirement? I mean, I think this is the #1 issue. And so I wanted to point out in the executive order where the language is that we're talking about, so you get a little bit of clarification, okay? So in the executive order, in its executive order 115, they talk about masks. And in that order, what they say is that any individual who leaves his or her home or place of residence must, and this is an important legal issue here, okay? So must wear a covering over his or her nose or mouth, such as a homemade mask, scarf, bandana, or handkerchief, when in any enclosed public space, which in my opinion would include libraries here, unless the individual is unable to medically tolerate a face covering. So we're going to unpack a lot of this here, but I wanted to point out that the onus here is on the individual who leaves their home must wear a mask, okay? So what does that mean when you talk about being a business or in a case of a place of public accommodation like a library, okay? Well, it says businesses and building owners or those authorized to act on their behalf. So most of you own your own building. If not, you've leased space and you're authorized to determine who comes in, okay? And in that language, it says businesses or building owners and those authorized to act on their behalf are permitted to deny entry or access to an individual who refuses to comply with the subsection B, okay? In this general provision, it doesn't say these businesses must deny entry. And there are other types of businesses, mainly you can see like restaurants have different rules. I don't have it at my fingertips, but the salon rule says that customers must be wearing face masks, okay? So what this says is that you as an individual, I have a responsibility when I enter a library, I must wear a face mask, okay? You are permitted to deny me access, but it doesn't say you must deny me access. So I think the obligation for enforcement really is on the individual here. Now, can a library enforce the mask rule? Absolutely, yes. It says specifically you are permitted to do so. So if you're a library and you want to enforce the mask rule, you are entirely permitted to do so, okay? So I want to make that clear. Some libraries are deciding whether it's worth it. And what I mean by that is there's a fear that there will be confrontations by patrons if you require them to wear a mask, okay? I get that, and I think that's part of the process, and I think that's part of the risk assessment that you're going to need to talk about with your lawyer. Okay, there's some libraries, for example, up in the UP and up in Northern Michigan, that if they enforced this mask rule, they'd probably be the only business or organization in town that did so. So you might be in a different situation than someone, say, in Macomb County or the Metro Detroit area where there's a higher number of cases and a higher population. Okay, so these are the individual risks that you need to take. Okay. The other issue I want to talk about with masks before I turn it over to Mike is that unable to medically tolerate the face covering. I think there's quite a bit of discussion on this, okay? And so this gets you into a weird sort of a Disabilities Act issue. Rule of thumb is that if someone says that they can't medically tolerate it, I'd probably stop there and allow them to enter the library. One of the common questions I'm getting is, can you give them the alternative of curbside service? Now, this comes into a reasonable accommodation issue. And I think in some ways, this is one of the areas I'd really like you to talk to your particular attorney about, because it may be a reasonable accommodation in some circumstances to offer curbside service. But let's say it's for computer use, so you can't replicate the service curbside. You may be required then to let that patron enter. That does not mean, to me, that your staff has to serve them or go within 6 feet. I think you can still apply all the social distancing rules to that particular patron. I don't know any library that's required by any policy. If your policy has this, it should be changed to service a particular patron at a particular time, for example, on the computer. Most of the policies I see say that, you'll do your best efforts to serve the people, but you're not required to do so. So keep that in mind as you're looking through your policy. That's just my general overview, Claire. If I've gotten anything massively wrong on that issue, let me know. Otherwise, I was going to turn it over to Mike.
I think that the only thing that I'd like to bring up or add is that I've gotten several questions from libraries that want to know if they can just refuse entry to someone who's not wearing a mask because of a medical issue. And I don't think that they can. So that's something that I would be curious on your take.
Yeah, I would, and that's something I would talk to your particular lawyer about, but I think that's very, very risky. If someone says I can't medically tolerate it, to some extent, I think some of this is going to be like, comfort animals or service dogs, where you just have to rely on it, even though you question whether a, comfort chameleon really is a comfort chameleon. You know, it's one of those things you just sort of have to take it on the face value. So I agree with Claire. If you were going to deny access for someone who who says they can't medically tolerate a mask, that decision should be made only after you talk to your lawyer about it, because I think it is very risky.
We did get a question that asked if a patron has to carry medical papers to state this, but I think that goes, like you said, the animal issue. I know you don't for like service animals and things like that. I think that probably, I'm not the lawyer here, so I'll refer to you, but probably falls under that umbrella where you can't require that.
I wouldn't. I think in this case, you're just going to have to accept what they say and not delve into it too more. And that's the same. It's the same issue with service dogs. You really can only ask 2 questions. You know, is this dog necessary to, you know, I forget the exact wording, but you really can't ask them for papers, can't ask them for medical diagnosis. You don't really want to know the information. So my personal thought is that you have to trust people here. But Mike has sort of an interesting hot off the presses issue that may impact the masks and, you know, some of the discussions you might want to have with your attorney. So I wanted Mike to be able to talk about that before we got into any other mask questions or any other issues too.
Yeah, from an employment perspective, a lot of the issues are the similar or the same. There's the accommodation issues that you have on access to the library, and those issues are on the employment side as well. But to give you an overview of where you need to address the reopening of the library from an employment perspective is you have to start with the requirement from the governor's executive order that you have a preparedness and response plan before you reopen. And the plan has to be available for inspection by the employees, government agencies, whoever wants to see it. And it has to be in place and available within 14 days of reopening. So you have to make sure that you do have your reopening plan in place when you reopen. And the reopening plan must tie in to the CDC guidelines and the OSHA guidelines. The governor's executive order specifically ties in to the CDC and OSHA guidelines, which change over time. So you need to make sure that you're reviewing the most recent CDC guidelines and OSHA guidelines and complying with them, because the governor's order will automatically shift to incorporate any new requirements in those guidelines. The other thing you have to keep your eye on, and this is going to be different depending on where you're at, is each county has a Department of Health. The health department, they have different names for them, but each county has a health department that has the authority, and most of them, if not all of them, have issued orders on what you must do to be open and to allow employees into the workplace. And so those requirements may differ from county to county. I know that Wayne County had a requirement for wearing masks. That has now been rescinded. Oakland County was the same. Oakland County's was also rescinded. Some other counties, I believe, still have in their local health orders a requirement for masks. So that's where I would start, is contacting your local health department and seeing if they require it. Because if they do, you're not only going to be at risk of a local ordinance violation or health department order violation, but that's going to be incorporated into the governor's executive order. So you're going to have a violation of the executive order as well. So that's really where you need to start. If the health department does not require masks, then the question becomes, from an employment perspective, must you require employees to wear masks? And my opinion is that it depends on what your reopening plan is and whether you can comply with the requirements for social distancing as to whether you must. And the reason why I say that is the executive order, the one that's currently in place, is 114. It replaced 97, but they're very similar, if not identical, in these respects. And what 114 requires is not only to have your reopening plan, but you must provide training and you must make available to all employees masks. So at a minimum, you have to have masks available, and you must provide training on how to wear them, how to wash them, the sanitation and whatnot. So if you don't provide that training and have the masks available, you're in violation of the governor's executive order. Now, do you absolutely need to require that the employees wear them? That raises a couple of issues. Number one is your plan must comply with the safety requirements, which are social distancing, the 6-foot rule. If somebody is in close contact, which is 6 feet for an extended period of time, which is about 10 minutes or so, then yes, they must wear masks. If you can comply with that social distancing rule by executive order, you do not need necessarily to require the employees to wear masks because you're not within the CDC guidelines on social distancing and safety precautions. Can you? Yes, you absolutely can. You can implement a requirement that all employees must wear masks as a policy. Some employees don't like that. They don't want to sit in their little areas if they're not near anybody. So there's going to be some HR issues there, but there would be nothing illegal if you had a policy that said you must, unless, and this is where the accommodation comes in, unless somebody cannot medically tolerate a mask. And if that is the case, then you cannot refuse to allow the employee to work simply because they cannot medically tolerate the mask. So now you're in the ADA accommodation area. And the accommodations that you could provide an accommodation of remote work. You could provide an accommodation maybe of a leave of absence, but an unpaid leave of absence, I do not believe would be permissible under the ADA. You can't take somebody's paycheck away from them because they have a medical condition. So and I get this question a lot, and I've dealt with a number of clients on this exact issue, is somebody says, well, I'm not comfortable coming in because I'm in a higher risk category, and I think everybody should wear a mask, and if you're not going to require the mask, then that is violating my rights. And so what I've said is the accommodation is what the employer is willing to provide, as long as it's an effective accommodation. So what you can do is make sure that you can comply with the social distancing, make sure that somebody is not going to be in close contact with any other employees, or in libraries situation, any patrons. Isolate them. I had one client that actually closed off a conference room that they weren't going to be using anyways, and made that an individual's office, isolated just for that employee, nobody in, nobody out, no chance of any contact. And my opinion was that was a reasonable accommodation. So a lot of these are going to be fact sensitive. They're going to depend on the exact circumstances. But if you don't have a plan in place and you don't accommodate employees with health conditions by requiring social distancing and all of the other sanitation requirements under the CDC guidelines, then you will have a problem with failure to provide a reasonable accommodation. The other area from an employment perspective that comes in is under OSHA. In Michigan, it's enforced through my OSHA, but the OSHA regulations are the same, and it requires that all employers provide a safe work environment. A safe work environment in the COVID-19 world means you're not putting anybody at unreasonable risk of contracting COVID-19. So if you fail to do that, you could be in violation of the MIOSHA standards and be subject the library to liability for the either a serious or what they call a other violation under MIOSHA, which comes with some fairly stiff fines. So you need to make sure that whatever the safety standards that OSHA has implemented, and OSHA has a website, they've got their standards for opening, reopening in view of COVID-19. So you need to take a look at those. They're very similar right now, almost identical to the CDC guidelines, but you need to make sure that you're complying with OSHA's guidelines on safe work environment. And that gets me to what Ann was talking about. Yesterday, there was a court injunction issued. This was in Cook County, Illinois, Chicago. And it was McDonald's. There were 3 McDonald's restaurants that were going to open, wanted to open, and they had their plan in place. They did most of the things they did in accordance with the guidelines. But there was a lawsuit filed. There was a request for a preliminary injunction preventing them from opening on theory that they were not taking enough safety precautions to ensure the safety of the workers. And the injunction was granted. And the lawsuit was filed. It was filed under Illinois' nuisance law. And they said by providing or requiring these employees to come back to work without taking sufficient precautions created a nuisance, and the court precluded them from reopening unless they did primarily 2 things. Number one, wear a face mask. Now this is the restaurant industry. So, and in Cook County, I think in restaurants, they require face masks, at least for the employees. And they, the McDonald's did have in their plan for face masks, but they hadn't provided sufficient training, at least to the judge's satisfaction. And there was testimony that some people's masks were sliding down and they weren't enforcing it or whatnot. And the judge says that's creating a nuisance, it's creating a health hazard, so you can't do that. And they also said that there was insufficient training of employees on all of the social distancing and sanitation. So the judge said you cannot open until you correct these issues, and that lawsuit is still going on. So we'll see where that goes. Here for libraries, I don't think you have that exact issue because you don't have an requirement of face masks of all library employees, but you still have the potential of MIOSHA citations and local health department order violations. So those are the issues that I see. I can't give you a bright line in every situation, do this, if that. That's just not how the employment world works. But if you follow the guidelines that I've been talking about and have a plan in place and train the employees on what they can and cannot do, you're going a long ways to protecting the library from liability.
Mike, one question we got in, I know you talked a lot about Executive Order 114 and how that relates to the employees. Does that relate the same way to, does it extend to volunteers within the library the same way as it would employees, or are they treated differently?
Well, volunteers are not employees necessarily. Volunteers are exempt from a lot of the employment laws, but for purposes of reopening and having the volunteers do tasks on behalf of the library, I would put them in the same category. I think they are going to be covered at a minimum by the MIOSHA rules for a safe work environment, even though they don't have the rights under some of the discrimination laws or whatnot. They do have a right to be in a safe environment. So yes, I think 114 would apply to them as well.
We got a couple other questions that I just want to pose to you. So I know you talked a lot about the reasonable accommodations for employees. I'm going to use the example of making the conference room into a private office. But what if the employee themselves doesn't have the health issue, but they're concerned because someone they live with does? Do you have to make accommodations at that point in time?
If somebody is in close contact with somebody that's positive for COVID-19, the answer is yes. If somebody simply lives with an individual in a higher risk category, that would not necessarily trigger the same issues, because being higher risk can be anybody 65 and over. Now, that in and of itself isn't going to trigger some of these obligations. In fact, you can't use the simple fact that somebody's in the higher risk category as a basis for refusing to allow them to come back. That would be discriminatory. But if it is COVID-19 related, that there is somebody that has tested positive or has symptoms, so it's directly COVID-19 related, and they have been in close contact with that person, then yes, they should be treated the same as if the individual themselves had the symptoms.
And then one other question before I turn it back over to Anne to ask her a couple things. Excuse me. How long do we need to provide that reasonable accommodation? The question here says, if an employee does not want to work with the public due to an underlying medical condition, but that was the job they were hired to do, is this just into perpetuity or until there's a vaccine, or what's the obligation on the library at that point in time for the duration of providing that accommodation?
Well, any accommodation issue remains in place as long as it is reasonably necessary. For our purposes, I think you need to watch the governor's executive orders, and Michigan has a reopening plan, and the reopening is in phases. Right now we're in phase 4, and as you progress through the phases, the risks decrease and the restrictions are lessened. So once Michigan hits, and this could be different from region to region, but once we hit phase 5, you're probably going to have totally different requirements. And then if we hit phase 6, they're gone. So at the worst case scenario, once Michigan enters phase 6, these requirements would go away.
Okay, thank you. Just to turn it back over to Anne for a moment, we did get one question that came through on the chat, just about guidelines and policies for handling of books and returns and things like that. I know there are some policies that are in place. I don't know if that's something that you can speak to, from not from the employment law side, but from just handling of materials in the library, what the obligation is to keep patrons and employees and everyone there safe.
Now, and Claire can contradict me if I'm wrong here, but I don't believe there's any current executive order that mandates that. Claire, is there? I know that they've been talking about that issue.
Yeah, no, right now there isn't. The work group that the governor's work group that we've been on, that was something we suggested, but we're still awaiting the final outcome of that. So yeah, right now there is no official time period. I know that the Realm study came out with some suggestions. I think it was either this week or the end of last week, which kind of amount to, I think, 3 days or 72 hours if an item can't be sanitized. But again, that's not anything that is, enforceable or.
Yeah. That's what I want to make sure. Thanks, because Claire's been working on, on some of these more library-specific rules. It just, and then there's talk, but I haven't seen an official, word on it yet. I think it should be, if it's something that should be as a matter of policy of the library, how they're going to handle it. I mean, certainly, I think 72 hours is safer than 48 hours, but that's something that, the cleaning, I don't think it's not mandated anywhere.
Oh. And I also just have to add, Claire, I love that you kind of faded in from Wonder Woman and became, it was perfect. It's like, oh, it's Wonder Woman and now it's Claire. One question that we did get was about opening special hours for people in high-risk categories. is it legal to restrict those access to certain groups at certain times? Like I know some retail stores have done that, or to have access to the building only on appointment basis?
I don't have, I'll kind of take that in parts. I don't have a problem with access on an appointment basis because I'm assuming if that's the situation, it's a first come, first serve. And if you're making certain groups make appointments, but not others. For example, if you're making people who are over the age of 65 make an appointment, but allow the rest of the public in, that's a problem. But if everybody's by appointment, I actually don't have a problem with that from a legal perspective. Okay, that's gonna be a policy of the library. Right now, the current executive order, if you're not in region 6 and 8, and if you are over 50,000 square feet of public space, and I think there are very few libraries in Michigan that are in this category. I know there's a lot of libraries that are over 50,000 or probably 25 maybe, but the amount of public space I'm finding is less than that. Those very small categories of libraries, so if you're over 50,000 square feet of public space and you're not in 6 and 8, the executive order actually requires you to have special hours, at least 2 hours a week. Now, so the question is, the executive order requires it for these libraries. Should other libraries be considering it? If you had asked me before this those who did ask me before this executive order came out, I would tell you that makes me very uncomfortable. That you're a place of public accommodation. People have a First Amendment right of access. Your regulations have a very high constitutional standard to meet. And so you're different from Meijer and Target and those stores who can, let people in and out with a little bit more ease. So I don't recommend it. I think it's fraught with problems. If you do want to do it, again, I hate to sound like a broken record, but this would be a conversation. If a client wanted to do this would be a conversation. I'd have a specific conversation with them about what the risks are, because I think you need to have that here.
Yeah, and I think, I definitely am going to, I'll make a point of mentioning it at the end, and I know it was in the registration form, but definitely talk to your own lawyers about anything, and don't take this as definitive, legal advice. It's really just information for informational purposes and discussion. So please, before making any of those decisions, consult the lawyer for your specific library and jurisdiction and the lawyer that you work with. So, so there was a question just about minors and children. Do you know, and I can ask this to either Ann or Mike, although Ann might be better because I don't think any children or, young children working in the library, but is there a difference in policy or enforcement for young children 3 to 17 in Mass? It says, I know children under 2 don't have to wear them, but what about children 3 to 17?
Well, I think the executive order doesn't, as I'm looking at it here, it doesn't make any special differentiation for kids. So I would treat that kids the same way you would the adults.
Okay.
And I think the science supports that there's equal chance that a 16-year-old could be a carrier versus a 32-year-old or a 65-year-old. So I think the policy behind it is sound as well.
Another thing that we got some questions about is the responsibilities in the library in terms of contact tracing and monitoring in case someone does get sick. Can you, either Ann or Mike or Claire, speak a little bit to what the responsibilities of the library are at that point in time? If someone is diagnosed with COVID-19, that's either a patron that has spent time at the library or maybe an employee, what is their responsibilities and how would that vary depending on whether it's an employee versus a patron?
Mike, you want to handle the employee part first?
Yeah, and I think it's going to be the same, but the requirements, if the library is aware of somebody, whether it be an employee or somebody in the library that has tested positive for COVID-19, or even has, the symptoms, what the library is required to do is to talk to that individual. First, isolate that individual, obviously get that individual away from everybody else, and then have a discussion with the person about where they were in the library, so all of the areas in the library, and who they came into close contact with. So that requirement is for this exact contact tracing, because once you know what areas they're in, then you have to shut that down and sterilize it and deep clean for the areas that they were in. But with respect to the contact tracing, the individual should identify everybody they came into close contact with, 6 feet or closer, for a prolonged period of time. So if it's somebody way across the library, they weren't even in that area, that person wouldn't have to be notified. But for anybody that was in close contact, that person has to be told that there was an individual you may have come into contact with that is positive for COVID-19. You cannot identify who that person is. That would be a violation of the ADA privacy rules. But you must say that you may have come into contact with somebody with COVID-19, and you are encouraged to consult with your medical provider and follow their recommendations. You do not need to have a blanket notice out to everybody that came into the library. But if somebody was patron came in and the employee helped that individual, then yes, the patron would have to be identified and told the exact same thing. So it doesn't really matter in this perspective whether it's an employee or a patron. It's anybody that came into close contact with somebody that has COVID-19.
Mike, my understanding, I've tried to do a lot of research on contact tracing because of this privacy thing, that the onus, just to clarify, is on the person who is ill. So the library does not have to, should not be keeping lists of people.
I think that's correct. Yeah, the individual, well, let me back up. The onus is on the individual, but the library, when they have to react to what they knew or should have known. So it's a knew or should have known. So once they know that there was an individual, tested positive for COVID-19, the library does have an obligation to take that further. Talk to the individual. Do you have an obligation to second guess that individual, to test? Is that person telling me the truth? No. You can rely on what that individual says. But if you don't ask that individual who they came into contact with and then follow through and notify those people that the individual did identify, that would be a violation of the library's duties.
I think too, part of the issue is, and to Claire's point and to Mike's point, that you're most likely going to get notification from your employee. They're going to call you up and say, I can't come to work because I've tested positive for COVID. If you have a patron who comes into your library on a Wednesday and tests positive for COVID on a Sunday, the odds that that person would call you and tell you that, first of all, are pretty limited, I think. And then I think maybe to the extent you could figure out if that person checked out books and one of your employees came in contact. But I think it would be virtually impossible, because we're not suggesting here that there's a requirement or that libraries should, take the names and contact information of everybody who walks in just for contract test tracing purposes. I don't, unless Claire disagrees with me, I think that's not at all required. So I think if a patron comes in and a patron calls you and later says, I was in the library on Wednesday at 11 o'clock and I tested positive for COVID, then we can decide what to do with that particular circumstance. But I suspect, as a practical matter, you're going to get more of the issues with your employees, and that's why we're kind of focusing on that.
And it's unlikely that the contact tracers at the state are going to call the library and ask for a list of people.
Yeah, I don't see that. I think you have to worry about it more if your own employee tests positive, and then what do you do vis-a-vis your employees and then any patrons they know they came in contact with.
And again, it's within 6 feet for 10 minutes of sustained contact is what the contact tracing site says anyway.
Right. And another issue that I probably should mention is under the local county health department requirements, if you do have a report that somebody tested positive for COVID-19, particularly if it's an employee, you do have an obligation to report that to the health department.
Thank you. That was very informative. I was not aware of some of that, so I appreciate that. We got one question in from Megan that I think is really interesting. It says, if we're limiting appointments to one person to a computer, can we turn away someone who comes in with kids and just wants them to hang out there while they work on the computer? So how does that work in terms of accommodating groups that may have small children? Do they count as additional people, or how would that work if you're limiting it to one person at a computer or at an area at a time?
Well, I think as a practical matter, you know, this might be something you want to take into account when you're developing your policy. This scenario exactly, like what would you do, and should that be your policy? I don't think that you're going to have too much trouble from a legal perspective if you limit it to one person per computer. I think it's going to be mainly one of those confrontation issues. There's a viral video going around of a woman who tried to take 2 kids into Costco and could only take one, and she threw a fit and put it on the internet. So I think you're more apt, you know, because when you talk about discrimination, I think, you know, I would probably at least allow this. I'd allow person have one child with them potentially, or people who may have a disability that need assistance. So I think the one person rule is sort of okay depending on what the circumstances are. But I'm a little bit uncomfortable because if you've got someone with a disability who needs assistance, I think there should be accommodations for that. You know, and if you've got, you know, think about a situation if you've got a mother who's got twin infant kids here, you know, and you want her to set those kids, you know, 6 feet back from the computer. I think probably the best case scenario would be to limit one adult and then, you know, decide what you want to do as a matter of policy, probably leaving the kids. I think that would be probably easier for the library, but that's something that you could talk to your lawyer about the risks on that.
That's one of those individual situations to that specific library that needs to be determined.
Yeah, I think probably that may be more trouble than it's worth because of the potential pushback you're going to get. But that's just my personal opinion on that.
So right now we have about 15 minutes left, and I just want to open it up. I know that I've asked a lot of questions that have come through, but I want to open it up and see if anyone on the call would like to unmute themselves and add anything or ask any questions to any of our speakers. If not, we can continue our discussion, but I want to open it up for some more conversation. And I'm not seeing anyone mute themselves, so I think they're all just sitting back and enjoying their coffee and spending their morning.
I have one.
What?
I have one.
Yeah. Oh, Cindy, thank you. I did not see you.
Yeah. So, yeah, there are other numerous questions in the chat. I was just wondering if I've split my staff into 2 shifts to minimize crossover between the 2, so that if someone is exposed, it's only that team that would have to self-quarantine until they can be tested. But my question is what is the obligation of the library in terms of coordinating the testing? Are we able to require that those employees go get tested, or would we have to pay them to self-quarantine instead? I tend to err on the side of planning for the worst and hoping for the best. So I'd like your thoughts on that.
Well, under the CDC guidelines, the self-quarantine under the direction of the medical provider. So it's important that it's under the advice or direction of a medical provider, but that is generally the 14 days. But there's a second test, which is if they have a negative test and the symptoms, there's no symptoms and it's a negative test, they can come back in 72 hours. So the question is, whose choice is that? Currently, under the EEOC guidelines, employers can require testing. So you could require that an employee get tested. The context that I've seen that in, though, is you cannot come back to work until you have been tested and it's negative. So that is the exact issue the EEOC has addressed and said, yes, right now that's permissible. Once we go into phase 6, that's no longer going to be permitted because that's a medical test. It is not allowed once we hit phase 6, but as long as there's a direct threat because of COVID-19, you can, as an employer, require the testing. Whether you can require the test as an alternative to the staying out for 14 days is I think it's a tougher issue. Generally, the accommodations are what the employer is willing to provide. So I suppose, I would think that as an employer, you could say you must get tested. Whether you can say you must get tested within these 14 days earlier, so you can come back earlier, I would not recommend doing that. First of all, this is supposed to be under the guidance and advice of the medical provider. So the medical provider is the one that usually would say, yes, I think, under this situation, you should be tested. And that's where the test will come in. If that's negative, then you can come back. I don't know that I would recommend as an employer to jump into that relationship between the individual and the medical provider.
Thank you. We've got a couple questions in the chat box about academic libraries as well. I know we've talked a lot about public libraries, but for an academic library, is it recommended that they create a plan specific to that department, or would they just fall under an umbrella of a reopening plan for the institution that they work for?
I would think that, so when you talk about plans and who adopts the plans, you think who's the governing body of that organization. So I'm assuming that these public libraries, if they have their own board of trustees or have their own enforcement action, they should have their own plan. If they're under the umbrella of the university, I think it's fine. I would make sure, though, that whoever develops the plan addresses libraries specifically. We've all seen that in the legal world where there's statutes that come out and they don't really address, well, how does that work with libraries? So I think whatever plan they have should incorporate libraries, and it wouldn't hurt for those libraries to reach out to whoever does the plans on behalf of their particular university to provide suggestions or to make sure that they're covered. So I think that's probably the best course of action.
We also got a question about meetings in Region 8. Are they allowed, do you know, within the executive orders, are they allowed to start hosting meetings in their meeting rooms if they're in the regions that are in phase 5?
I believe so, because let me just check. Just so everybody knows, the governor did extend the executive order on remote meetings. And so you are still allowed, regardless of what part of the state you're in, you're still allowed to have those meetings. So I want to point that out. That's till the end of July, at least. That's the executive order. I think as a matter of just generally to libraries, you still have to comply with whatever capacity restrictions that you have on your library. So if you're not in zone 6 and 8, you still have those occupancy restrictions. And depending on the size of your library, some of the smaller libraries can't have in-person meetings because they're so restricted. So if the restrictions are lifted like they are in 6 and 8, that would allow you to reasonably think that, you could have a meeting inside and still maintain those restrictions. I think you're permitted to do so now. The library has to remain open though. So if you are not open to the public or you're just doing curbside, you can still have the meeting as long as you don't, bump up against any capacity restrictions, but you do have to allow the public into that meeting space during the time of the meeting. You can't lock the doors and so forth. So that's the issue. So I think it's encouraging that you still can have a Zoom remote meeting, so you don't have to worry about that. If you're at all worried about the capacity restrictions, probably zone 6 and 8, you're not. And so those are probably safer. But if you're a small library and you have a small capacity restriction, in your board members and maybe two, the director and the 2 employees that come to the meeting will take up all that capacity. Plus you have to keep people 6 feet apart, I believe, still, even in 6 and 8. And so that's another thing to keep in mind.
Thank you. It says, or the board can meet outdoors, right? So there's another option. We've gotten a few other questions here about the meeting rooms and about just what is the responsibility on the library? And I'm going to combine one of the questions we just got with another one, but in terms of enforcing social distancing, if they rent out their meeting room, or what is the responsibility for enforcing social distancing between patrons? Like if patrons are complaining about other patrons being, within that 6 feet, I guess where does the library's responsibility in enforcing that end?
Well, I think that the social distancing restrictions are required, and there's not the same sort of, it's interesting because there's some in the executive orders, it says that no one's going to be liable for not wearing, individuals not going to have individual liability for not wearing face masks. They say that, libraries are permitted to deny entry. And so there's not the same sort of, I think, guidance for libraries about what would happen. I mean, I think it would be a violation of the executive order since the libraries are required to have the social distancing in effect. But whether anyone's going to enforce that or not, Claire might have some additional thoughts on that.
No, I agree with you. I think, yeah.
You're gonna get, so I've just seen it, kind of in my own life. You see there's people that are on one hand extremely afraid to go out now, and then you see the people who are think it's almost a hoax, right? And then you've got everybody in between. So if you've got a very afraid patron in the library at the same time as I think it's a hoax patron, you may have these types of issues. I think asking people to keep 6 feet apart is reasonable. It's required by the CDC. It's required by the executive order. There's going to be nothing wrong with requiring that. It's going to be more of a situation where I know you had someone who has a de-escalation, about de-escalating and trying to work out. That's where you're going to have a problem. I think from a legal perspective, you can enforce the social distancing. I think there's no, I liken it to speeding a little bit too. And, anyone who drives on a highway above 70 miles an hour is breaking the law, right? And are the police obligated to pull everyone over? Obviously not. You don't have that time and energy. So are you obligated to make sure people are going down the aisles, according to the arrows? No. Are you obligated likely to kind of address and respond to complaints? Probably. Just like the police, if they see you going 100 miles an hour, they're going to pull you over, right? And that sort of selective enforcement, if you want to call it that, is acceptable, I think. So I think this is one of those things you have to kind of use your common sense. Don't have people, don't walk around behind patrons, making sure they're going through the aisles the right, but if someone's in the, within 2 feet of someone, coughing on someone, and someone complains, I think you should, probably take some action to investigate it.
Well, and it's always that kind of loophole or catch-all in your policies, which is, if someone is preventing someone else from, using the library or enjoying the library, then that's, if someone is coughing on somebody, they're interfering with somebody else's use of the library. And chances most of you have some kind of policy that's something like that. So if you remember, what you're doing is enforcing your policies, and enforce them just like you would any other policy. And if it gets ugly, then it's not a matter of enforcing your policy. It's a matter of, controlling someone's inappropriate behavior.
And the reopening policies that we've done address the social distancing and incorporate that into a policy that you can enforce. So, your general patron behavior policies, like Claire said, can become very, a nuisance is a nuisance, regardless of what time it is. But when you drafted those last year or even in January, you weren't thinking about masks and social distancing. That's why we did that specific policy related to reopening that is a supplement, I think, to that it specifically addresses these issues, and you can use that for enforcement purposes. Especially, but if you're going to enforce it, make sure your policy has an appeal provision in it.
We got one question that just anyone could answer this, but what entity enforces the executive orders? Is it the sheriff, the local police, the state police, all of the above? Who's responsible for the enforcement of those executive orders?
It's a misdemeanor, so I think any law enforcement agency has the authority to issue the misdemeanor ticket. So that's part of the issue. You've got libraries that are not really tasked with enforcing the the violations of an executive order. And as you've seen in the news, you have sheriffs all over the state taking different stances on whether they're going to enforce it or not. So
one of those kind of situational.
Yeah, it would probably be, I would start probably with if you have an issue that you think there's a violation of the executive order by a patron and you were inclined to call the police, again, I think I would talk to your lawyer before you did that, but I think I would start with the local law enforcement officers, whether that's your city police or, if you're more rural, it typically is your county sheriff.
So we have about 3 minutes left. So with the time that's left, I just want to give Anne and Mike, and I'm going to open it up to Claire as well, since you've been so gracious and kind of in the moment become a third panelist. So I appreciate it. But I know we've thrown a lot of questions at you. I know that you three have gotten a lot of questions as well. If you could kind of sum up, one simple piece of advice or kind of a guiding principle that libraries should, follow as they enforce these policies and work on these policies and go deeper into reopening phases, what would your suggestion be? I mean, I'll start with Anne.
My suggestion, I've just seen libraries struggle with this, primarily because all of you, well, most of you, I would say, are rule followers. I mean, we're all, you want to do the right thing, you want to follow the law, you want to follow the rules, right? And so it's very frustrating when you, one, don't really know what the rules are, and then two, when you feel like the rules may cause you to have significant customer, client tension. So one thing I think is just people need to remember that you, like everybody else, are in a situation where this is totally unprecedented. We're all trying to figure this out together. So if you don't know the right answer, and I think really, and the policies that I've drafted, you got to be flexible. So if you open up and you require masks and it's a disaster and your staff's unhappy and you're unhappy, be flexible enough to reevaluate. And that's why whatever policy you have, the one that we drafted has the board approve the policy, but after that, it has the ability for the director to make changes to, really to address these issues that we're all kind of working through together. So kind of give yourself a break. This is hard and it's not easy and there's not clear answers, and be flexible and make the changes in your library that you think are necessary.
Mike, I'm going to turn that over to you. Do you have any?
Sure. I think the most important thing I can share is to make sure that you have training. We're talking about health and safety, and we're talking about requirement standards under OSHA and MyOSHA. And if you do not have proper training, it's really not going to matter much else what your defenses are, because you're going to be found to be in violation for failure to properly train. So you have to have your plan in place. You have to make sure that all of the managers and supervisors are well aware of everything in the plans. And then you got to carry that out to the employees. You have to have the staff meetings, make sure that the employees know what's in the plan, what to do in every situation. That's why that injunction was granted in Chicago, was because of the lack of training. That was the most important piece of it. So it's not enough to have a policy and post it on a wall somewhere and say I'm in compliance. You're not. you have to make sure that you follow through and train everybody.
Thank you. That is great advice. And Claire, I don't know if you have anything else that you would like to add to either Ann or Mike's points.
Well, Ann stole what I was going to say.
I'm terrible like that, Claire. Sorry.
No, which I love because it just means that I'm on the right track. The only other thing that I would say is read the executive orders. I know they're boring, but read them. And I would say if you don't have a lawyer, please hire one. It's definitely worth the cost. And I don't want to give Ann that much more work. Well, maybe I do, but she, and ask. If you don't know and you're not sure, just ask. And, either LM or MLA or, Ann, we'll do our best to give you, either send you to someone who we know can help you, or we'll give you, the answers that we have. But if you don't ask, then you risk just stepping your foot in it and, not getting into trouble. So that's what I have to say.
Claire, to that point, I just want to make sure on your website, I saw Shannon posted a link, but you've done I think, you've done a good job of putting together some of the places where some of that training material can be found. Is that?
Yeah. And I actually watched all of them to make sure that they had the criteria that was in the MIOSHA stuff. And I went through the MIOSHA and the OSHA regs and guidelines. And so to the best that I can see, and if Mike wants to take a look, we would love it, that they should be helpful. So yeah, it's on the LM website. It's a list of training materials.
And if you, and Claire said, call anybody to see if you can't find a particular training material, let us know. I've done a little cheat sheet for the identifying, what is the word? Identifying potential. I'm losing my. The patron, trying to figure out who's managing symptomatic patients.
Yes.
I developed a cheat sheet, but see, and this is a good example. I started with what the CDC recommended for homeless shelters to how you identify someone who has COVID. So there's nothing really geared towards libraries, and to what, kind of follow up what I said earlier. We're working through this with you. So if you can't find something, let us know. We'll certainly be able to help.
Well, we're all out of time, but I think definitely the advice of being flexible, being thorough, and then if librarians are great at anything, it's reading and finding answers and asking those questions. So I think we're ready to go. And I thank you, all three of you, and for joining us and answering our questions. And I thank everyone that's on the call for joining us today. I hope everyone has a wonderful rest of your day. Next week, due to the 4th of July holiday, we will not be having a coffee hour, but we will be having one the following week. So enjoy your holiday week, and thank you again for everyone for joining us, and have a wonderful day.
Amber, thanks for inviting us too. I appreciate it.
Yes, thank you.
Thank you, guys.
Thank you.